Welcome to the Deep Dive. Today, we're setting aside maybe the grand monuments of Rome, the Colosseum, the aqueducts, and looking instead at the invisible structure that really made it all work.
The legal system.
Exactly. Specifically, Roman contract law. We're talking about the sophisticated legal architecture that underpinned, well, arguably the most powerful economic engine of the ancient world right across the Mediterranean. Our goal here is to get past the usual history points and really dig into the nuts and bolts. How did the Romans actually make sure business deals stuck? How were promises kept?
It's such a crucial area because the whole system, everything from, massive state building projects down to just lending your neighbor some grain, it rested on this one core idea, pacta sunt servanda.
Agreements must be honored.
Agreements must be honored. Simple as that. And to make that happen, the Roman jurists, they developed this incredibly practical, effective legal framework. And honestly, a lot of modern commercial law still bears its fingerprints.
It's fascinating, though, because when you trace it back, the origins of this really rational, adaptable legal system seem, well, anything but secular, almost sacred, wouldn't you say?
Oh, absolutely. That's a fundamental point you find in the sources. Early Roman law and Roman religion, they basically grew from the same seed. Religious law wasn't separate. It was part of the civil law.
And administered by the same person initially.
Yes, originally the rex, the king, he handled both. So breaking a promise, defaulting on an agreement, it wasn't just letting down another person. It was seen as challenging the gods, the divine order itself.
Okay, that makes sense for the early days. But Roman law became famous for being pragmatic, adaptable, perfect for commerce.
Yeah.
How did it shake off that initial sort of sacred rigidity? Roman religion stayed pretty conservative, didn't it?
It did, and that divergence is really where you see the genius of the Roman legal mind. Roman religion, it expanded, but kind of mechanically. They'd conquer people and just add their gods to the pantheon. It grew outwards extensively. Roman law, though, it expanded differently. It grew organically, intensively. It was incredibly pragmatic. It constantly looked at what people were actually doing, Greek traders, Egyptian merchants, you name it, and absorbed their practices, their experiences.
So learn from the ground up.
Exactly. This willingness to adapt to real-world commercial needs, that's why it worked so well for this huge multi-ethnic trading empire. Adaptability was absolutely key.
So if we boil it all down, strip away the layers of complexity in this massive, adaptable system, what's the single most common tool they use, the lubricant for this whole economic machine?
Well, you'd almost certainly land on the verbal promise, the stipulatio.
The stipulatio. Okay, so this is the cornerstone we need to understand.
It really is probably the most common, the most enduring type of Roman contract. And its defining feature, maybe surprisingly, is its simplicity. At its heart, it's a unilateral verbal contract.
Unilateral meaning. It mainly creates an obligation for one side, the debtor.
That's right. Even though two people are involved in making it, the promise flows one way. And you used the right word earlier, Ritual. This was definitely not a casual agreement.
Not just, hey, lend me $100.
Far from it. The absolute defining characteristic was its rigidity of form. It had to be done in a very specific way. A formal question from the creditor and then a matching formal answer from the debtor.
And the wording had to be precise.
Extremely precise. It wasn't about capturing the general idea or intent. It was about proving that those specific words were spoken in that specific order.
Okay, give us the classic example, the textbook version.
The creditor would ask something like, "Do you solemnly promise that 100 gold pieces will be given to me? Centum aureos mihi spondesne."
And the debtor had to reply using that same formal verb.
Exactly. He had to reply, "I solemnly promise, spondeo." If the creditor asked using spondesne and the debtor replied with a different, maybe less formal verb like prometto, I promise, well, technically.
The whole thing could be invalid, just for using the wrong word.
Potentially, yes, especially in the earlier, stricter periods. The adherence to the formula was paramount. It sounds incredibly picky to us, but that formality provided certainty.
And the sources say this format, this stipulatio, it wasn't just for simple loans. It could cover almost anything.
Pretty much anything. Any kind of obligation you can imagine could be framed in this question and answer format.
Oh, yeah.
It was like the ultimate legal Swiss Army knife.
Utility knife.
And it wasn't just for creating new obligations. It was also used heavily for, let's say, legal housekeeping, tidying up existing deals.
How so?
Well, imagine you had an existing debt. Maybe it arose from some informal business deal. Maybe the terms were a bit fuzzy. You could essentially convert that older, perhaps complex obligation into a brand new, crystal clear stipulatio.
And that process had a name.
Novatio, novation, replacing the old obligation with a new one in this standardized verbal form.
Why bother? Why standardize old debt like that?
Well,
What was the advantage for, say, the Roman marketplace?
certainty and simplicity in enforcement. If you have a 5-year-old debt based on services rendered, proving the details in court could be messy. But if you use novatio to turn it into a stipulatio,
Then you just have to prove the formal promise was made.
precisely, you replace a potentially complex and arguable original situation with a simple, universally understood, easy-to-litigate debt formula. It made commercial claims much more secure, much more fungible, almost.
Okay, so the spoken words, the formal exchange, that was the legal core. But practically speaking, managing an empire's trade just on spoken promises. It seems risky. People forget. People lie. This leads to that tension, right?
Yeah.
Form versus proof.
It's a really common point of confusion because legally, strictly speaking, you didn't need any witnesses for a stipulatio to be valid. The moment those words were correctly exchanged, boom, the legal obligation existed.
Just the words themselves.
Just the words. The validity rested entirely on that verbal formality.
And yet,
Yeah.
we know the Romans were meticulous record keepers.
Yeah.
So where did written documents fit in? You mentioned the cautio. What was that?
The cautio was essentially a written memorandum recording that the verbal stipulatio had taken place. It wasn't the contract itself, but it became incredibly common, almost standard practice, to draw one up immediately after the verbal exchange.
Often with witnesses.
Yes, often signed by witnesses. Because while it wasn't legally necessary for the contract to exist, it was hugely important for proving it existed, especially later on or if disputes arose.
So let's say a debtor denies making the promise. The creditor pulls out a cautio signed by witnesses saying he did. How would a Roman judge look at that?
The cautio carried enormous weight. It created a very strong presumption that the verbal exchange actually happened. In fact, later imperial laws went so far as to say that if a properly drawn-up cautio existed, the court would presume the words were spoken.
Wow, so the burden of proof shifted.
It shifted heavily onto the debtor to prove something extraordinary, like they weren't even physically present, or there was fraud involved. It shows the law evolving, really, recognizing the practical needs of commerce and the security offered by written records, even while maintaining the fiction that the verbal form was supreme.
Okay, so the promise is made, maybe recorded. What happens when it's broken? The debtor doesn't pay the 100 gold pieces. What legal tools did the creditor have? The actions seem quite specific.
Highly specific. For the straightforward breach of a stipulatio failure to pay a definite sum of money, certa pecunia, or deliver a specific thing, certa res, the main weapon was the condictio.
The condictio, what kind of action was that?
It was a very old, very formal, strict law action. Its aim was purely recovery, get the money back, get the specific item back, not much room for nuance.
But what if the promise wasn't for a fixed amount? What if it was a promise to do something or not do something? A service, maybe?
Ah, right. If the obligation was less defined, something the Romans called incertum, uncertain or indefinite, then the condictio wasn't suitable. For those cases, they developed the actio ex stipulatio.
The action from the stipulation, how is that different?
It was much more flexible. Unlike the condictio, which just claimed the specific sum, the actio ex stipulatio allowed the judge, the iadex, to assess the situation and award damages based on the creditor's actual loss or interest in the promise being fulfilled. It could handle much more complex scenarios.
So condictio for simple recovery, actio ex stipulatio for more complex stuff, but both stemming from that initial verbal promise. But what about deals that weren't just one-way promises? What about, exchanges? Barter, more complicated arrangements. The stipulatio seems ill-suited for that.
You're absolutely right. The stipulatio, being unilateral, wasn't great for bilateral contracts, where both sides have obligations arising from the exchange itself. Think about contracts where my obligation only kicks in once you've done your part.
Like a sale, maybe? Or those innominate contracts where the categories didn't quite fit?
Yeah. Exactly. For those, the jurists had to get creative and develop other specific actions. Actions designed for unique, often reciprocal situations.
You mentioned an interesting example involving silver goblets. That sounded quite specific.
It is a classic case from the sources. Imagine someone loans silver goblets, but the agreement isn't for the borrower to return those exact goblets. Instead, the deal is they return an equal weight of silver bullion.
Okay, so it's not quite a loan of the goblets, not quite a sale. What is it?
It's an innominate contract. It doesn't fit neatly into the standard boxes. And if the borrower fails to return the silver bullion, you can't use a simple condictio for the goblets because that wasn't the promise.
So how did the law handle it?
The creditor would bring an actio prescriptus verbis, literally an action with words written beforehand.
Right.
Meaning, the formula for the action, the instructions given to the judge, had to be specially drafted up front, prescriptus, to describe the specific facts of this unusual agreement. It was a way to handle customized reciprocal deals that the standard actions couldn't cover.
And the level of detail in that claim is really telling, isn't it?
Yeah.
It wasn't just for any silver.
Precisely. The claim wasn't just for, say, 5 pounds of silver. It was for 5 pounds of silver of the same quality as the silver used in the original goblets.
Wow.
It shows this deep Roman legal commitment to making the injured party whole, aiming for true restitution. You don't just replace mass, you replace value and quality. It's remarkably sophisticated.
That focus on detail, on quality, on securing value. It leads us straight into how they protected the actual assets backing these promises. Making the promises step one, but ensuring it's secured by something tangible. That's the next level.
And the Romans were incredibly advanced here. When it came to using property to secure debts, they had really sophisticated tools. The two main ones you hear about are pignus and hypotheca.
Pledge and mortgage, essentially.
Pretty much. Pignus is the pledge, where the debtor actually hands over possession of the collateral, think jewelry, maybe some goods to the creditor.
Yeah.
Very secure for the creditor.
But not great for the debtor if they need the item.
Exactly. If the collateral is your farm equipment or the shop you work in, giving up possession isn't practical. That's where hypotheca, the mortgage, came in.
How did that work differently?
With the hypotheca, the debtor kept possession and use of the asset, the land, the ship, the workshop, but the creditor was granted a legal security interest over it. If the debtor defaulted, the creditor could then claim the asset.
That sounds much more flexible for business. You can borrow against your assets without stopping your operations.
Immensely more flexible. It was vital for commerce. And what's really striking is how forward-looking their approach to these security interests could be.
You mean covering future assets?
Yes, the sources are clear. You could have a clause in a mortgage agreement stating that it covered not just the debtor's current assets, but also future acquisitions.
Seriously. So if a merchant mortgaged his current warehouse stock, he could agree that any ships he bought later would also automatically fall under that same mortgage.
If it was agreed upon, yes. That clause was generally held to be valid. It allowed for much larger lines of credit, essentially, secured against the potential growth of the business. Shows real confidence in economic expansion.
Let's get into some of the nitty-gritty details the jurists worked out. There's a fascinating point in the sources about crops, the fruits, from mortgaged land. Why would the law protect someone who bought and consumed those crops, even if the land itself was collateral?
This is a classic example of Roman legal balancing. Okay,
Yeah.
so the land is mortgaged, and maybe the agreement specifically says the mortgage includes the fruits, the harvest. So legally, the crops are part of the security.
Right.
However, if a third party comes along, buys the harvested grain or olives in good faith, pays for them, and maybe even consumes them, that buyer was generally protected. They couldn't typically be sued by the creditor holding the mortgage on the land.
Why not? Seems unfair to the creditor.
The reasoning was partly about the nature of the asset. Once harvested, fruits are separate from the land. They're perishable, easily transferred, meant for consumption. And partly it was about protecting market transactions.
Protecting commerce.
Exactly. Imagine the chaos if every buyer of grain had to investigate whether the farm it came from had an outstanding mortgage covering the crops. Trade would grind to a halt. So the law prioritized the smooth flow of goods in the marketplace over the creditor's claim on that specific consumable item once it reached an innocent third party.
So the creditor's recourse was against the debtor, not the random person who bought the wheat.
Precisely. It protected the integrity of everyday market dealings.
Okay, shifting gears, slightly managing money. Interest rates. Always a tricky subject, often politically charged. How did Roman law handle limits on interest, especially when collateral like land was involved?
They were quite clever about it. Usury laws existed, setting maximum interest rates, but lenders and borrowers found ways to work within them, often using the collateral itself. Well, one common clause was to agree that the income generated by the mortgaged property, say, rent from tenants or the value of the harvest, would be used to pay off the interest first, before touching the principal. This was generally fine, as long as the effective interest rate didn't sneak above the legal limit.
And I remember reading something about promising higher rates, but only if you defaulted. Was that allowed?
Yes, that was another interesting mechanism. You could agree on a standard legal interest rate, but you could also agree contractually that if the debtor failed to pay that rate on time, a higher but still legal rate would kick in.
Like a penalty clause.
Essentially, yes. A penalty for default, structured as a higher interest rate. It incentivized timely payment without actually breaking the usury laws from the outset. You could call it early financial engineering, really, designed to manage risk within the rules.
Let's turn to another area where finance and law intersected heavily, the dowry. This often involves significant assets, land, promissory notes. The law seems very concerned with fairness and fraud here, but often in disputes between the husband and wife.
Dowry was a major economic transaction, and yes, the law had to deal with things going wrong. Take the example of a promissory note included in the dowry. The wife gives her husband a note where some third party owes her money, and now that debt becomes part of the dowry owed to the husband.
Okay.
Now, what if that third party debtor goes bankrupt before the husband can collect? Or maybe the husband just doesn't get around to collecting it quickly enough. Could the wife then sue the husband for the value of that failed note, claiming he should have secured the money?
What did the law say?
Generally, no. As long as the husband wasn't actually fraudulent or grossly negligent in trying to collect the debt, he wasn't held liable if the third-party asset failed. The jurists felt it was unfair to make him bear the risk of the original debtor's insolvency just because the note came via the dowry.
So the risk stayed with the origin of the asset, in a way.
In a sense, yes, unless the husband messed up. Now, a more complex case involved dowry land. What if the husband receives land as dowry, starts farming it, and then suddenly someone else shows up with an older, valid mortgage on that land and evicts him?
Ouch. So the husband loses the land. Can the wife still demand the value of the dowry back from him?
This is where it gets tricky, especially concerning fraud. If the husband was evicted and he wasn't himself negligent or fraudulent, and if the prior mortgage was due to some shady dealing by, say, the wife's father who provided the land, then the husband could actually raise the defense of fraud, exceptio doli, against the wife's claim for the dowry value.
Even if the wife herself had nothing to do with the father's fraud.
Yes. The sources suggest the jurists thought it was fundamentally unjust for the husband to lose the land and still have to pay the dowry value back, when the whole problem originated with the wife's family who provided the faulty asset. It shows the law trying to trace the fault back to its source, even within the family providing the dowry.
All this complexity, securing debt, handling fraud, valuing assets, it implies a need for public oversight, doesn't it? Commerce couldn't just rely on private lawsuits.
Absolutely not. And we see clear evidence of this in specialized officials in courts. The Aediles Curules are a prime example.
The curule aediles. Who were they?
They were specific magistrates, fairly high-ranking, who had dedicated jurisdiction within the marketplaces, especially the main forum in Rome. Their very existence tells you that regulating daily commerce was seen as a public function, a state responsibility.
What kinds of things did they handle in these market courts? What was their beat?
Their focus was very much on fair dealing and quality control, particularly in the sale of two key commodities, slaves and livestock.
Why those specifically?
Because defects in these weren't always obvious. The aediles enforced rules about disclosure. If you sold a slave who had a known disease or a tendency to run away, fugitivus, or even specific vices, you had to declare it.
And if you didn't?
If you didn't disclose a known latent defect, the buyer could bring an action before the aediles. They had the power to force the seller to take the slave back and refund the price, or to grant a reduction in the price reflecting the defect. It was basically consumer protection law for the ancient world, focused on these high-value, high-risk market transactions.
A specialized layer of commercial justice.
Exactly, providing quick, expert resolution for market disputes that the main civil courts might not handle as effectively. It underscores how embedded legal regulation was in the fabric of Roman commerce.
But even as the law got incredibly detailed about contracts and markets, its application wasn't uniform across the population, was it? That brings us squarely to the huge role of personal status in the Roman commercial world. #tag3. Status and legal standing in the commercial world.
Yes, you can't understand Roman commerce or Roman law generally without grasping the concept of status. The whole system operated on a spectrum of legal rights and capacities, from full citizens at the top down to people with effectively no rights at all. And perhaps no group illustrates the link between commercial function and legal status better than slaves, the servi.
The sources even define slavery in a way that sounds more like resource management than anything else.
It's quite stark. The jurist Florentinus, for instance, notes that the word servi, slaves, comes from servere, to preserve, because generals preferred to sell captives rather than kill them. They were seen as mancipia, things acquired, property.
But not just any property. They weren't just laborers in fields, were they? Especially in urban settings or large estates.
Oh, absolutely not. While many slaves performed manual labor, slaves also filled crucial roles at the higher end of business and household management. They were agents, accountants, managers, skilled artisans, even doctors and teachers. Owning skilled slaves was also a huge status symbol.
And this ties into the idea of the peculium.
Directly. The peculium was a fund or collection of assets, money, goods, even other slaves sometimes, that a master allowed a slave to manage as if it were their own. Legally, it still belonged to the master, but functionally, it was the slave's working capital.
So a slave could run a business using their peculium.
Yes, often acting on the master's behalf, but with considerable autonomy. This peculium was vital to Roman commerce. Now, what happens if the slave himself is used as collateral? Say, the master mortgages the slave. Does the peculium automatically go with the slave if the creditor forecloses?
Good question. It seems like it should if the slave is property.
But the law added a crucial layer. The creditor could only claim the assets in the slave's peculium if the mortgage agreement specifically included a clause to that effect.
Even if the slaves acquired those assets after the mortgage was made.
Yes, regardless of when the peculium assets were acquired. The default position was that the peculium was separate unless explicitly included.
Why the distinction?
Probably to protect the ongoing business operations associated with the slave and their peculium. It prevented creditors from unexpectedly seizing the working capital that might be essential for the master's other enterprises, unless that was clearly part of the original deal. It required specificity in the security agreement.
Roman law seems obsessed with these fine distinctions, even within the category of unfree.
It really was. They had numerous categories. Take the stat syllabur. This was a slave who was promised freedom, manumission, in their master's will, but conditionally.
Conditional on what?
It could be anything. Maybe they had to pay a certain sum of money to the heirs or perform a specific task first. Until that condition was met, they were still legally a slave. But crucially, they held a legally recognized expectation of freedom, a kind of limbo status.
And at the absolute bottom of the scale.
You had the service pone. This wasn't someone born into slavery or captured. This was a person, often a former citizen, condemned to slavery as a punishment for a serious crime. Think hard labor in the mines, or being sentenced to fight as a gladiator.
What was their legal standing?
Practically non-existent. Critically, they were considered to have no master, nullius. Even the state wasn't technically their master. And because they had no master, they could never be manumitted. Their enslavement was permanent and inescapable, a complete civil death.
Moving up the scale to free people involved in commerce. The complexity must have required agents, managers, people acting for others. Does the law recognize these roles?
Oh, extensively. Roman commerce was too big for owners always to be present. The legal texts are full of discussions about instadores. These were agents formally appointed to manage a specific business, like a shop or a shipping venture. The master was generally liable for the contracts the instator made.
And what about less formal arrangements?
They also discuss negotiorum gestores. This is a fascinating category, someone who steps in to manage another person's affairs without being asked, perhaps because the owner is away or incapacitated. The law had rules about the obligations and potential liabilities arising even from this unsolicited management. It shows a really mature system dealing with sophisticated business delegation.
And when these business relationships, like partnerships, went wrong, if one partner damaged the business,
liability could get complex. Let's say a partner negligently damages property that belongs to the partnership. Maybe they crash a jointly owned wagon.
okay.
For that, they could face the standard action for damaging property, the aquilon action, acte legis sequilie. That's just basic tort law.
But what if their action didn't just damage the wagon, but harmed the partnership itself? Maybe they scared off clients or ruined a deal through their carelessness.
Exactly. The jurists, figures like Celsus and Julian, recognized this distinction. The partner wasn't just liable for the physical damage under the aquilon law. They could also be sued using a specific action on partnership, the actio pro socio.
A separate claim.
Yes, a separate claim focusing on the damage done to the partnership as a business entity breaching the trust, harming its operations or finances. So, One bad act could lead to two different types of legal liability, recognizing both the property damage and the injury to the commercial relationship.
It's often assumed Roman law was just for Romans, for citizens. But you mentioned earlier that non-citizens got legal recourse quite early on.
Yes, and it's a really important corrective to that assumption. The evidence suggests that one of the very first permanent jury courts established in Rome, the Quaestio Perpetua de Repetendus, dealing with extortion by officials, actually provided a remedy primarily for provincials, non-Romans who had been exploited.
Before similar courts existed just for citizen disputes.
Even before the older, citizen-focused popular courts, Idicia Populi, fully declined, it strongly suggests an early recognition that if you wanted stable trade and governance across the empire, you had to give non-citizens meaningful ways to seek justice, especially against Roman officials. Pragmatism again.
But even with this reach, equality before the law, that wasn't really a Roman concept, was it? Especially when it came to personal offenses like insult or injury injuriae. Status seems paramount there.
Absolutely paramount. The treatment of inuria is one of the clearest windows into Roman social hierarchy. The term covered a broad range of wrongs, from a simple verbal insult up to physical assault, but the punishment depended massively on who did what to whom.
On the persona, the status of the people involved.
Precisely. Both the victim's status and the perpetrator's status mattered enormously.
And how did the courts handle this? Was it a fixed fine depending on status?
Generally not for inuria. It was usually handled extra ordinum outside the strict formulaic court procedures. This gave the magistrate, often the praetor or a provincial governor, much more discretion. They'd look at the facts, the severity, the intent, and critically, the status of the parties.
And the sources draw a very sharp line based on status for the punishment itself.
Unmistakably sharp. The commentaries explicitly state that free men of lower status, liberi humilioris locae, the humbler sort if found liable for inuria, could be subjected to physical punishment, beaten with rods, fustibus subisuuntur.
Corporal punishment for free men.
For the lower status free men, yes, but for those of higher status, the anestiores or simply cetera, the others, the penalties were different. No beatings. Instead, they faced things like temporary exile or being forbidden, interdictio from certain places or activities, social and political sanctions, not physical pain.
So the same offense could lead to a beating for one man and temporary exile for another, purely based on their social standing.
That's the reality the texts describe. It was a legal system deeply embedded in and reinforcing the social hierarchy. And even when monetary compensation was involved, its value could become outdated.
You mean the fixed penalties?
Yes, like the old 12 tables penalties for certain injuries. Labor jurists comment that the praetor could set a value, estimatio, for an injury to a free man, reflecting its severity. But they also note that amounts that might have seemed substantial centuries earlier were, by their time, considered laughably small due to inflation and changing values.
Which leads to that famous legal phrase,
Sed nunc alio iure utimur. But now we use a different law. It's a fantastic acknowledgement right there in legal texts that the law wasn't static. It had to adapt, even in valuing personal injury, to remain relevant to the current social and economic reality. That constant pragmatic adjustment is a hallmark of Roman law. Hashtag tag outro.
So pulling all these threads together, what really stands out from this deep dive into Roman contracts and commercial law?
I think it's the sheer scale and honestly the ingenuity of what they built. They started with something incredibly simple, that formal verbal promise, the stipulatio. And from that foundation, they constructed this immense detailed architecture covering everything: security, debt, fraud, market regulation, agency.
A whole system designed to make pacta sunt servanda agreements must be honored. A reality across a vast, complex economy.
Exactly. And while it was incredibly pragmatic, constantly evolving, as we saw with the aediles in the marketplace or extending remedies to non-citizens,
It was never divorced from the society it served. That status element is unavoidable.
completely. The solutions were detailed, often quantified, aiming for fairness within a given transaction, but how that justice was ultimately applied, the actual consequences, could differ dramatically depending on whether you were honestier or humilior, higher or lower status.
The Roman jurists, then, were masters of practical regulation. They created a system where even messy things like debt, arguments over quality, personal insults, they were all channeled into specific legal actions, specific procedures, quantified and managed.
A legacy of structure and process that profoundly influenced Western law.
So the final thought for you, the listener, navigating our own complex world of contracts and legal systems, much of which still uses Roman terminology. What should we take away?
Perhaps it's that tension. We inherit the logical structure, the quest for certainty, the specialized tools from Rome, things incredibly valuable for commerce and order, but we also inherit the echoes of that status-based application of law.
The difference between being beaten with rods or facing exile.
It's an extreme example, but it highlights a fundamental question that remains relevant. Does our legal system, in practice, deliver the same consequences, the same protections, the same justice, regardless of a person's wealth, connections, or social standing?
Are the rules applied with the same force to the powerful and the vulnerable?
Exactly. That distinction the Romans made so explicitly between the humiliores and the rest. Maybe it's less explicit now, but the underlying challenge of ensuring truly equal justice, that remains a constant struggle, a vital point of scrutiny for any legal system claiming fairness thousands of years after Rome.
Something to definitely keep in mind. A very insightful deep dive.